jump drive came. We actually looked at it, and all that was ever on it was photographs. There was never any videos on it. You know, we have any photograph that we've gotten, we've been more than happy to say, yes, we've got those 6 videos simply weren't there.
Well, it seems there's a dispute here. I don't know how I can resolve that, except to say that let's just find out what these videos are about. Is there something in these videos that the state is concerned with? Do you know what the contents? Would you like to review them now?
Yeah, we haven't even seen them.
Okay.
We have seen them. We gave them to you yesterday, and they were looked at by somebody and returned to me yesterday.
Well, this is what I'm going to do. I'm going to give you a chance to take a look at the videos. What's the length of these videos?
They're minutes.
The minutes. So take a look at these. How many of them are there?
There's 7.
7 few-minute videos. We give the state an opportunity to review these short videos and then make a determination as to whether or not there's some sort of unfair surprise that's a result of whatever it is that is contained therein. So I guess I should give the jury a short break. Give them. Yes.
And not to interrupt, but on the same issue, Judge, they also provided us with several pictures this morning that we have never received either. We've gone through the photographs, the 2,000 that they sent us. In fact, one of the pictures that they introduced yesterday was a picture of the ladder in the yard. That is something that was never provided to us. That was the first time we saw them yesterday. We're continually getting discovery as we're sitting here, and that's unfair to the state. And as far as those pictures are concerned, she gave us 2,000 pictures. So to now start giving us more pictures, I think that those at least should be excluded.
How many pictures are we talking about?
I'm withdrawing those pictures. If they say they haven't, they can do it.
Thank you. So withdrawing. So let's take are we still, who is our next witness?
Next witness is Summer Wells.
All right. Why don't you just, let me go back to the note issue. Is Ms. Pugh giving us the note?
Yes.
Can I see this?
I told her how long.
Okay. All right, here's her response. She says, okay, I can schedule the test Monday, Tuesday, or Wednesday. I will call my recruiter on break and see when I can schedule. I can see if I can take it on Wednesday. The test starts at 9 a.m. I believe I will get confirmation after lunch break. So the party wishes to look at this response.
I don't need to, not even thank you.
Okay, we made it part of the record. And I'm sure we'll get an update from her after the lunch break. Tell the jurors we're going to need another 15, 20 minutes or so, and so they can be on break until, might as well make it half an hour. Let's say 9:45. At 9:45, they're to report back to the jury room. Yes. Okay, ladies and gentlemen, welcome back. Good morning. I apologize for the delay. Good morning.
Yes, Your Honor, the state just wants to make a correction as to evidence that was tendered in. We have a duplicate of 197, which is what the DVD and photograph. We're going to renumber the photograph as 197A.
Any objection?
No objection.
All right. Mr. Bell, please call your next witness.
Call Summer Wells to stand.
Summer Wells. Up here, please. Turn the sample. Hey, what case is your record? Any small disclosure?
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You have a seat, and if you would state your name for the record and then spell it.
My name is Summer Wells. It's SUMMERWELLS.
Ms. Wells, what is your relationship to Joseph or Jennifer Rosenbaum?
I'm Jennifer Rosenbaum's sister, and Joseph is my brother-in-law.
And how were you raised first to get to know Jennifer?
We grew up in foster care. We had visits throughout foster care.
And at about what age do you remember the first visit? Do you remember how old you were when you first got to know Jennifer?
6 or 7,
And were you ever placed together?
maybe a couple times.
Did you become aware at some point in time that Jennifer was going to foster 2 little girls?
Yes, I did. Back in, it was June of 2015 when I met the girls, me and my son.
And where did you meet them?
We went to a birthday party for the Zeckler's daughter. That was Jason and Lauren Zeckler. They invited me and Malik to a birthday party. We had been going to different events with them over the summer. They had a birthday party at their house for her.
And did you go on any outings other than to Jennifer's house? Did you go with the girls to any outings?
Yes, we did. We went through several different outings over the summer. We would go on, me and my son got zoo tickets, to the free zoo tickets. We took the girls to the zoo. It was before Father's Day that year, the day before Father's Day. I think the girls were still at, I think the lady's name was Mrs. Lambert. Had them up from there. She talked with us for a little bit, and she gave Jennifer DVD players for her car, and then we left from there and went to Walmart and got Joseph Father's Day cards and swim trunks. They were blue swim trunks.
Have you ever been in the car with Jennifer and the girls? Been in the car with Jennifer and the girls when the girls fell asleep?
Yes, on the ride back from the zoo, they fell asleep with.
What occurred as a result of them?
What do you mean?
Was there any punishment as a result of their sleeping?
What do you mean?
Did Jennifer punish them for sleeping? Did Jennifer punish them for sleeping? I can't ask it any better.
No.
Okay.
There would never be a form of punishment for sleeping. We stopped at Sonic and got ice cream on the way home. The girls needed to be returned to the Lamberts. They had something to do for Father's Day the next day.
Have you ever seen Jennifer spank or hit the children for any reason?
No. Yes.
Can you tell me a little bit about when that was and where that was?
I had to watch the girls for her moot court event in September, and then there was an occasion where she went to an engagement party for Sana in October. I had to watch the girls then. They were fed, bathed, and I had to watch them when she went to that. They were fed and bathed and put to bed. They were dressed.
Did you see any bruises, cuts, or lacerations on them?
I mean, normal kid bruises and scratches and stuff. My kid is normal bruises and scratches. But
broken arms?
No.
Broken legs?
No, not at that time, no.
Bruises on the back? Bruises on the stomach?
No.
Did you see the girls in October and November?
Yes. On several different occasions.
Okay, can you tell me about that?
On October 15th, I had to pick up my boyfriend in Bainbridge. My sister had to watch my child. Then, when I came back that evening, the girls were being dropped off by Peggy Banks. That would be the first time I met them. That was the great-grandmother. That's all I heard about her until the next time that I would see them at the birthday party. But on October 15th, the girls and my son played outside, and
Did you see any bruises, cuts, lacerations?
didn't see any bruises, cuts, or lacerations. Playing like the rest of them, she was just sitting there. So Jennifer checked on her, and she didn't tell us what was wrong with her. But Millie stated that she had fell at her Nana's house, so we picked her up and let her play. She did go back to playing with my child and Millie. So Jennifer asked me if she needed to see anybody, and I was like, if she's still playing, then no, she should be fine. And then I saw them again at the birthday party for Millie on the 17th at Noah's Ark. We walked around the sanctuary, and we did the fall festival.
Did you see either of the girls or both of the girls walking?
Yes, both of the girls walked. That would be the first time I met Kim Smith, the aunt. Both of the girls walked. We had cupcakes and ice cream, and the girls had their costumes on because it was a Frozen event, but we changed them out. Lauren changed out Layla and
Lauren who?
Zeckler.
Mm-hmm.
Lauren Zeckler changed out Layla, and then Jennifer changed out Millie, and we went to the fall festival event.
When you say changed out, were you
Fully unclothed.
Fully unclothed?
Yes.
Did you see any bruises, cuts, or lacerations, or bruises?
No.
Did she
No.
complain of her head hurting her or anything of that nature?
No.
Did Layla walk the whole time that she was there?
Yes, other than the free ride. My son rode the little free ride. The dog that was doing the little free ride, it was one free ride thing that every kid rode on. Even Lauren Zeckler's daughter rode on it. All of them rode on it. My son was small enough to ride in it, in the little cart. There was a little thing that they all rode on. It was just one free ride. And then they had little different events like the throw toss thing. It was a little fall festival. We all walked around it, and then we went through the animal sanctuary, and we saw all the animals, and they got to feed them and interact with the animals.
Did either girl complain of pain?
No, not that I remember.
Did
no.
either girl favor any legs or arms in any way?
No.
Did you detect any abnormality in Layla's arms?
No.
Did you feel them? Did you check them?
No, we didn't check them. I mean, Kim picked up Layla that day and gave her back to Joseph. And she went straight to Joseph, and then we went back to the party. It wasn't like Kim was there for the party. She was working at Noah's Ark that day.
Okay. Well, did she refuse to go back to Layla when Kim took Layla from Joseph? And tried to return the baby? Did Layla do anything to suggest that she didn't want to go to Joseph?
No, by no means whatsoever. Layla loved Joseph. She loved all of us. So did Millie.
Next time you saw the girls was when?
The end of October. My son always picked out his Halloween costume with his TT every year.
Who's his TT?
Jennifer. I'm sorry. That's what he calls her. It's a thing. They do it every year. So we went costume shopping with the girls. They already had their costumes, but he hadn't picked out his costume yet. So we went costume shopping with them.
And in what shape were they in on October 27th or thereabouts?
Layla had a cast on at that point.
Oh. What about Millie? Was she favoring an arm?
No.
Was she complaining of pain?
No.
Did Layla complain of pain?
She wasn't complaining of pain, no.
She didn't say she was in pain?
No.
When's the next time you saw the girls?
Early November.
And let me just go back to October. After you shopped for Halloween costumes, did you do anything else with the girls?
Yeah, we took them home that evening. I went back with Jennifer, and we took them home. Me and Malik ate dinner with the girls and helped them get bathed, and we stayed for a little bit, and then me and Malik went home.
And
after he tried on his costume. He always did that with my sister. Every year.
Was there anything, undressing the children for the bath, was there anything in late October that caught your attention, that alarmed you?
No.
Any bruises, cuts, or lacerations?
No.
When's the next time you saw the girls?
In the beginning of November, Millie had the thing on the square, in the McDonough Square.
What was that thing in the square?
Her gymnastics team was, they were introducing the Grinch. So I went to it. Jennifer had invited Peggy to go. She didn't go. I spent the night that weekend because Joe had to work that weekend. I spent the night. I went, I attended it, and watched my niece go introduce the Grinch.
Did Millie favor any arms or legs?
Not that I remember.
Was there anything about her that alarmed you?
Not that I remember.
You said you stayed at Jennifer's house. Is that does that happen with some frequency that you stay at the house?
Yes,
Have you lived there before?
I have lived there before.
Have you lived there where the girls are there?
No, not when the girls were there.
Lived in the house before?
Yes, I have lived in the house before.
Have you ever seen Jennifer and Joseph argue?
I mean, no. Not
They
like-
fight? What did you do on November 8th with Jennifer?
November 8th, we came back home. November 9th, we did she had a law event that we went to. And then after the law event, we came back and picked the girls up from Joseph, and we met with Peggy Banks at Walmart and McDonough. And then I took her out to eat for her birthday because she had all kinds of law exams coming up. After that, we met Peggy Banks back at Walmart, and she brought them back. And we went back home, and I left that evening.
How many times have you seen Peggy Banks with the girls?
I mean, they were unsupervised with her, so
I understand, but how many times did you see Peggy?
Several. Those couple times, and then but they didn't go with her. She left. She didn't stay for the birthday party.
Okay. You a couple of ones in
Come to Layla's birthday party at the house in July.
and in October, did you see her with the kids in October
At the birthday party.
at the birthday?
And yeah, on the 15th, like I said,
And when you saw,
she was just dropping them off. That was the first time I met them.
okay,
First time I met her.
and then you met her again at the birthday party at
Yes.
Noah's Ark.
Yes, I seen her there at the table. She was at the table. Yeah.
After the Noah's Ark.
Yes. Again
When
in
about?
November
In November of
2015.
2015.
Yes, ma'am.
Do you suffer from seizures?
I do.
Who has seen you have seizures? Rona, there's been talk about seizures and whether or not Jennifer would know what a seizure is, and I think therefore that is relevant.
Response?
Well, it's nothing to do with what happened in this case. Whether what her seizures look like are not relevant.
Sustain the objection.
Has Jennifer ever done the Heimlich maneuver on you?
No.
Has she ever done CPR on you, adult
No.
or child?
No.
Ms. Wells, I'm going to show you a number of pictures that I've already shown you to see.
Okay.
You take a look at them and see if you can identify them.
Yeah. This one is of me and Layla at the zoo.
Just look at them all and then tell us globally what they are.
Do I show them? Or?
No, don't show them. You just look at them and identify them for, tell us what their pictures are.
The outings that Layla would take with the family.
Okay.
And Millie, and at the house, and things that we would do with the girls.
At this time,
And birthday party.
Specifically, what are they as a whole?
Our family, of the outings that we took and the things that we did together. The memories that we had together.
At this time, Your Honor, I would tender Exhibits 177, 179, 181, 182, 184, 186, 188, 189, 190, 191 and 92, 194, 198, 204, 205, 206, 208, 207, 177 and 209, 200, 201, 202, 203, 200 and 199 into the record, and ask if they may be admitted into evidence.
Any objection?
No, Your Honor, no objection.
Prohibited.
Thank you. I want to show you what's been marked as Defendant's Exhibit 300 and ask you if you can identify it.
Videos.
Videos, what are they videos of?
The girls playing on trampoline out.
Can you speak up louder?
I'm sorry, I moved it. They would play on the trampoline outside in the sprinklers, outside on the sprinklers, and they would sing Frozen songs for Jennifer, and she would record them sometimes for their biological mother.
Were you either present or received those videos?
Yes,
Did Jennifer share a lot of videos and pictures with you?
yes.
At this time, I would tender Defendant's Exhibit 300 into the record.
Any objection?
No, I think objection. We'll want to step this way and stuff. Was personally there.
She said she was personally there for them or received them.
On my old phone. They're not on my current.
State's request charge number 1. I don't believe we get this done. This might be a situation where it's filed, but because of our malware incident, it didn't make its way to us. And so I can tell you that this is the first time I've seen this.
And I apologize for that, Judge.
It's
I have a problem
It has to be explained.
I think the first question
with objection. I say sometimes it can be confusing. I don't. We can.
is statute of limitations.
And I don't have a problem with it. I'm just saying sometimes it can be confusing. I don't have a big problem with it. It's not a huge objection. I said sometimes.
It has to be explained. It has to be explained.
I think the first question I would get back from the jury is, we always say that state permitted to prove its commission on any date within statute of limitations or within relevant statute of limitations. And I agree it would be better if we didn't have to do that. I think I have to.
That's fine. I'll add it to my PowerPoint.
All right. And let me take a look at the, I guess I'll just ask you to go to the next charge that you're requesting. It's not in my packet.
The indictment, the conjunctive allegation charge, which reads, when an indictment charges that a crime is committed in more than one way, the state is not required to prove the commission of that crime in every separate way or method alleged, but must prove that the crime is committed in at least one of the ways alleged. If the indictment alleges that a crime is committed in more than one way, and those alternative methods are joined with the conjunctive word and, then the state must prove beyond reasonable doubt that the crime is committed in one of the methods alleged, but need not prove more than one as alleged.
not sure what this is intended to capture. I know that the charges that I have on the offenses are track the language in the indictments. And does this relate to a particular?
So, for example, the murder counts, like the first 7 counts of the indictment, alleged blunt force trauma to the pancreas, liver, and mesentery. Let's say, for example, the jury is not convinced beyond a reasonable doubt on the mesentery for some reason. The defendant can still be convicted based upon the commission of one of those. They can find, but they do think that it was proven beyond a reasonable doubt as far as, let's say, the pancreas or the liver. That's what this language goes to. And I think it helps clear it up that maybe if there's one thing that they're like, oh, I'm not so sure, but what the indictment says, or what the law says, is that if it's proven in any of those ways, then the state has met its burden of proof.
Any objection to states too?
I think it's confusing. I think as written out, it's confusing. But I think it's an accurate statement of law.
And Judge, we can hone the language. Generally, I can tell the court when I address this in my closing portion of it. I just basically say "and" means "or" in Georgia. Like
That's what I've been sort of used to is a statement that "and" means "or."
I'm comfortable just letting you argue with not giving this charge if the party said that this charge is confusing.
I always prefer to have the charge, that way it has to come from the court, but if the court would like me to work on I can work with small on the specific language of this particular charge. Coming from the court, the specific law, I think that's important.
Well, I'm happy to give a version of it too. If you want to talk about that, that's fine. But otherwise, I'll just give the state's force charge too, and you'll be explaining what that means.
Thank you. And as far as state's request to charge 3, this is a law that actually just came out from the Georgia Supreme Court this year that says that where crimes involve relatives with close relationships, slight circumstances can support the inference that the party colluded. We would be asking that would be added to the section on party to a crime.
I think I have a problem with that. It suggests that less than reasonable doubt is the standard when it comes to family members, and that's not a statement of law.
And then just for the court, this cases are Berger, B-I-R-G-E-R, versus the state. That's 305 Georgia 281, came out this year, 2019. And then around the same time, the Supreme Court also released Solomon versus the state, 304 Georgia 846 219. It's not lessening our burden of proof. What it's essentially saying is that if there is this close relationship, then even slight circumstances can be inferred. And I pulled the language directly from, I didn't make this language up. This was the sentence that I pulled directly from the Supreme Court's opinion.
Just because it's language that comes directly from the Supreme Court doesn't mean it's appropriate for a charge.
Well, I'll take a look at it and go from there. But we also have aggravated battery definition of useless.
Yes, but this would just be regarding useless, does not mean it has to be permanently useless. And I cite to Christensen versus the state, 245 Georgia Appeals 165, and Webb versus the state, 228 Georgia Appeals 624.
I'm not saying to have in the rules.
We provided a copy to you on July 8th, 2019 when we filed. But I can get another copy from this mall tomorrow.
Well, this is consistent with everything that I've ever done in the area. I'm familiar with this case law. I think this is correct. It says, as it relates to aggravated battery, the term useless does not mean permanently useless and for loss of uselessness. I believe that's an accurate statement of all of it.
And then state's request 5, the court already came in as murder in the second degree.
Oh.
Let's see if I...
Is there anything about the remainder of the charge, the fact that I've submitted to you that gives you some pause for question?
Judge, in the venue section, 15110, we asked to be full. There's an extended charge.
There is.
That goes essentially that if let me get the back wording. That essentially if the venue can't be shown, then we can prove that it occurred in any form. Don't get me that. I want to take it up here.
It's that second sentence in the first paragraph of the standard charge.
Yeah.
If you'd like me to put that in there, I'm happy to do that.
I think it might be helpful, given the facts of this particular case. But in a prosecution, in any case where it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Through the end of that section, I think it would be appropriate given that in this case.
Okay, I can do that. I've taken out the premeditation charge, because that's not something that is that the pattern charge committee thinks has to be given absent a specific request by the jury. So remove that. I've taken out the principal failure to prosecute other persons involved charge. I've taken out the prior conviction limited purpose charge. I've taken out the prior difficulty between parties charge. I've taken out the limiting instructions purpose parties counts. I've taken out the statement charges. Statement of defendant standard of proof, statement of defendant voluntariness defined, burden of proof as a voluntariness, conditions precedent, consideration of statement, corroboration, defendant statement, limited instruction purpose parties counts. Those are the statement charges. I've taken them out because it seems to me that there's really no issue in the cases to voluntariness. There's no issue as to there was counsel present during the giving of the statement.
That's fine. We put it in there. You never know.
Out of an abundance of caution, yes. And as well, you agree that they're not appropriate charges under the circumstances in this case. There was an aggravated assault, so it's statutory extended definition. I think was provided by the state, taking that out. That was the intent of a very broad type of language.
I don't think we have that here.
And I've moved the malice defined from for aggravated battery, which had its own separate charge. I moved it into the aggravated battery charge. And beyond that, that's the nature and extent of my work. Ms. Moe, first of all, let me finish up the question that I've not addressed.
No, but in my understanding from the additional 5, the conjunctive allegation will come in. It's just a matter of us working on the language, correct?
Yeah, it might make more sense just for me to leave it in as it's stated that this is an accurate statement of the law. I think you contending that it is, and then you can address any perceived confusion during your closing, to the extent that you deem that to be appropriate. Okay. So the only thing that I have really left is this Vigo versus the state case to take a look at and see whether or not that particular charge from the state can become language with recent Supreme Court case. Is there anything from you, Ms. Moe? Everything's fine? Okay. And let me see. Let's talk a little about the length of time we're going to be engaging in this closing argument work. Can we, and the reason I'm inquiring is because I, of course, would like to keep the closing arguments together if at all possible. Do the parties agree that that's advisable?
Say something.
Yes.
Okay, so why don't we just plan to start with the closing arguments at 1 o'clock? That way we keep everything together, keep the charge with the closing, and it's all done this afternoon. So that gives me a little bit of time to sort of do this additional work that you have brought up regarding that one case, make a couple of little corrections, get you another copy of the charge, get your final feedback on the final product, and then just so that you know, I mark this as C1 and give it to the jury at the conclusion of the charge. So they have it along with the table of contents to refer to the extent that they need to at some point down the road. Is there anything else?
Nothing to say.
Are you limiting this to 1 hour, or is the capital case to go for 2 hours?
I'm not limiting you to 1 hour. I think you're 2 hours in the first paper rules. Okay, thank you both. And just give me about 20 minutes to get this in final form and bring it back up to you. Thank you. Oh, do we have any objection to the form of the verdict form?
No, you don't.
The indictment, conjunctive allegation, is at charge number 26. Dates of indictment is at charge number 31. Aggravated battery and definition of useless is at charge number 43. And of course, the venue is still where it was before. that additional language, just rather than having to try to call through that quickly, I would just direct your attention to exactly where those changes are.
Thank you.
Okay, anything else?
Discovered that there were some errors made on my part in the tendering of evidence. We tendered in all of the following pictures, but the numbering was wrong. So court reporter and I come to an agreement, the state is in agreement with us, and so I just wanted to put on the record. Number 177, we are not using number 177, and instead we have that last tender of evidence should read that Defendants Exhibit 210, 195, 183, 176, 187, 175, 193, 174, 171, 180, 196, and 180 should be included in the last package of photographs tender.
Can you judge by the state? Okay.
We have remarked the exhibits accordingly.
All right, thank you. Are we ready for the jury?
Yes, sir.
Oh, let's bring through. Welcome back, ladies and gentlemen. I apologize for the long delay. Unfortunately, just took a little time to do the work that we had to do, and we appreciate you being back here promptly at 1 o'clock. We've reached that point in the trial where the attorneys are given an opportunity to make their summations or closing arguments to you. The state has the burden of proof, therefore they have the right to open and conclude. What says the state?
We will, Judge.
All right, and will you open?
I will do the opening. I'll do the
All right, Mr. Chase.
Good afternoon. Been together for quite a while. It's coming to an end. I promise you after the next couple hours, the lawyers are finally going to close their mouths and you all will be able to do what you're doing. But we have a few more things that we just want to say to you before we get to that point. You all know that you've been here hearing this case in the state of Georgia versus Jennifer and Joseph Rosenbaum. We're going to review some of the evidence that you've heard over the past 2.5 weeks. Ms. Young told you when we first began this that they put up a facade. What they projected to those around them, what they projected to DFACS, what they projected to Layla and Millie's family, what they projected to everyone was a facade. And ladies and gentlemen, you saw that facade continue in this courtroom. That's what we have witnessed over the past 2.5 weeks. But as the evidence has shown, and as we are going to review this afternoon, the evidence proves beyond a reasonable doubt that they are responsible for the death and abuse of Laila Daniel. And they are responsible for the abuse of Millie Place. You've heard a lot of stuff that has nothing to do with Millie Place and Laila Daniel. You've heard things about Peggy Banks. She must be a racist. You've heard about Cynthia Tate. She might be an alcoholic. You've heard a lot of stuff to try to distract you from the truth of what happened. So let me remind you, this is why we are here today. We are here today because of Laila Daniel, a little girl who died far too young. And we are here because of Millie Place, a young girl whose life has been forever changed by the 4 months that she spent with these two people. Before we get too much more to that, my job here, I hope I can at least keep you somewhat entertained while we go over the law, because the law may not be the most exciting part, right? But it is really, really important. It's important that you understand when you go back into the jury room and you start analyzing the evidence and you start looking at the law that the judge is going to give you, what your job is. So what is your job? Every juror has a duty to follow the law and fairly and accurately seek the truth. Despite what the defense is going to want you to think, your job is not to seek doubt. Your job is to seek the truth of what happened to Laila Daniel and Millie Place. You are bound by the law and the instructions that the judge gives to you. Every juror has a duty to deliberate. If someone actually back there refuses to deliberate, you can bring that to our attention. What are some of the things that you should consider when you are back in that jury room? Well, kind of put it on the screen for you. The things on the outside are things that you shouldn't be considering. You shouldn't judge this case based upon passion. based upon any public opinion, whether or not you are unhappy with the police. If you were unhappy with the police, contact their chief. If I've done something or one of my coworkers has done something that's offended you, we work for Sherry Boston, the elected district attorney of DeKalb County, and I can guarantee you that she will take it up with us. But please, please don't take that out on Millie and Layla. Any public feelings, you shouldn't decide this based upon sympathy for the defendant, whether you have any prejudices, whether you disagree with the law, and you're not to concern yourself with the penalty or punishment. So your job here is to determine whether or not the state has presented enough evidence to prove all of the charges brought in that indictment. So what are the things you should rely on? You should rely on the statements, and the various statements that you've heard. Have you heard perhaps some conflicting statements come from the defendant? Those are things that you can consider. You can consider expert testimony. What expert testimony did you hear, and what expert testimony do you believe? You're allowed to use your common sense. We did not ask you to leave your common sense at the door when you came in 3 weeks ago. You're allowed to use your common sense when you judge the credibility of the witnesses, when you judge whether or not someone is telling you the truth. Testimony of the victim, testimony of witnesses that come in here, photos and documents, you gotta lie. Elements of the crime, and who has a motivation to lie? Who in this case has a motivation to lie? The defendant. These are all things that you should consider and are allowed to consider. So let's talk about some of those legal principles that you probably watched or seen when you watched Law & Order and CSI and all those crime shows. First one, the burden of proof rests upon the state to prove each and every material element beyond a reasonable doubt, and I stand here on behalf of my coworkers, and we proudly do that. We proudly stand here to prove what happened to those little girls. The presumption of innocence. The judge is going to tell you that there's a legal presumption that the defendants start this trial legally innocent. But that does not mean they are actually innocent. Because with each and every piece of evidence that we brought you, we've shown what truly happened in that home, what truly happened to those little girls. Just because there's a presumption of innocence does not mean the defendants are actually innocent. Reasonable doubt. That's the bread and butter. I can tell you that. I'll tell you a little secret. Don't tell anyone. Including the media. Don't tell anyone. I used to be a defense attorney. When I first started off, I was actually a defense attorney. And the bread and butter of defense is reasonable doubt. Trying to create reasonable doubt. Trying to confuse all of you. So let's talk about what reasonable doubt really is. Well, the judge is going to tell you it has to be reasonable. It's exactly what it says. It is based upon common sense and reason. See, once again, it's that common sense part. We don't want you to leave that at the door. It's not a vague or arbitrary doubt. I don't really know. It's a doubt for which a reason can be given. So if you're in the back, you're like, I don't really know. I don't know. That's not a doubt for which a reason can be given. We are not required to prove beyond a mathematical certainty or to beyond all doubt, because that's impossible. So what does it mean? It's the doubt of a fair-minded, which all of you are, impartial juror, honestly seeking the truth. Again, your job is not to seek doubt. I'm going to use a couple of examples as I talk to you this afternoon to try to distill these legal principles down, because I know it can be a lot to have us talk of all this law to you all at once. Let's assume for a second that I had a much more pleasant job. And my job was to prove to you that the photograph that you see on the screen is a photograph of a $1 bill. And as you can see, there are various puzzle pieces on the screen. And those would be the evidence and the testimony that had been presented during the trial. Now, as you can see, there's a couple of puzzle pieces missing. And what would the defense attorney say to you? If there's a puzzle piece missing, then the state hasn't met its burden of proof. But that's not what the law says. The law says that if you take a step back, you look at that entire picture, and there is no other reasonable explanation as to what that is a photograph of, then the state has met its burden of proof. The same in this case. If you take a step back and you look at all of the evidence that's been presented to you, and there's no other reasonable explanation as to what occurred to Millie and Layla, then the state has met its burden of proof. Talking to you a little bit about direct and circumstantial evidence. You're going to hear the judge talk to you about that as well. So do a little defining. Direct evidence is things that you can see. So photographs, videos, documents. You got a lot of them to go through. Testimony from witnesses, because when a witness took the stand and raised their hand and swore to tell the truth, that is evidence that you consider. Now, there may be some conflicts in the evidence, and you may have to decide who is telling the truth. Like, do you believe Dr. Darisaw or do you believe Dr. Sperry? But those are the things that you all can take into consideration. Testimony from the witnesses, what they saw, what they heard, what they felt, and more. So that's the direct evidence, kind of that tangible things that you can see and feel. So what is circumstantial evidence? And I'll tell you this. Circumstantial evidence in the law has the same weight as direct evidence. There is no difference in the law as to circumstantial evidence. Sometimes you hear on TV, oh, that's just a circumstantial case. In the law, that means no different. What is circumstantial evidence? So what you do is you take from that direct evidence, from those photographs or witness statements, and you can infer other facts that are reasonable and justified based upon your life experiences. See, again, that common sense thing coming in. There is no difference in the law, as I mentioned. I'll give you another example. Instead of being in the middle of July, when it's been nice and hot for the past 3 weeks, let's pretend that this trial actually took place in the middle of January. And we were getting one of those random snowstorms that we get every couple of years here in Atlanta. You leave jury selection, you leave the jury service for the day, and as you're driving home, you kind of look out of your window and you see those kind of dark, ominous snow clouds that you know from your life experience. You know, those look like snow. You turn on the radio. And when you turn on the radio, you hear the newscaster saying, there's a 90% chance of snow tonight. But when you get home from listening to me and Miss Young drone on and on all day, you are so tired that you have a glass of wine and you go to bed. When you wake up in the morning, you look out your window, and as far as the eye can see, all you see is white. You go downstairs, you open the door, you reach down, and you feel that cold white substance between your hands. You call your best friend who says, oh my gosh, did you see it coming down last night? It was absolutely beautiful. So what do we have? Well, we have the direct evidence, the things that you saw, those dark, ominous snow clouds. We have the white as far as you could see, and you could reach down and feel that cold white between your hands. You also have testimony. You have testimony of the newscaster that told you there's a 90% chance that it was going to snow. And you have the testimony of your friend who saw it come down. From all of those facts, that direct evidence, what can you infer? That it snowed last night. What's the defense attorney going to say? Did you see it? Because if you didn't see it, then you can't prove the case beyond a reasonable doubt. But again, that's not what the law says. The law says that unless you believe that some Hollywood movie company for no good reason decided to come in and spread snow as far as the eye could see to fool you in some way, that's not reasonable. But those are the types of things that they want you to believe in cases like this. You all are going to be in the position to judge the credibility of the witnesses who testified here in this courtroom. And you judge the credibility just like you would judge the credibility of any single person in your life. And I think we talked about that with some of you during jury selection. That's what you do when you judge the credibility of a witness. Do you believe that person when they got on the stand? Does it seem like they are credible? Does it seem like they maybe are being paid to say something versus someone who has dedicated their life to doing this type of work? I don't know, Dr. Sperry versus Dr. Darrisaw? Those are the types of things that you consider. Who you believe, who seems more credible to you. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. If you believe a witness when they got on the stand, if you believe Millie when she got on the stand, and she had to sit in front of an entire courtroom, scared to death, having to look over nervously at the people that she used to live with that caused her fear. If you believed her, when you looked at her, that's sufficient to establish what she said. But of course, we didn't spend the past 2.5 weeks just giving you Millie's statement. We gave you all the other evidence in the case. And I have up here the words cast director to remind me of one thing. I can only bring you evidence that we have. The only people who had a chance to decide what witnesses we'd be able to bring in are the defendants. They are the ones who decided not to abuse and beat those children in the middle of Lenox Mall, the middle of Target. They're the ones who decided what witnesses would be around. We can't bring you people we don't have. The judge is also going to tell you that the date is not material. There's a lot of dates in the indictment. You're going to see that. You're going to hear it again. There's a lot of dates in the indictment. For a lot of legal reasons that I won't bore you with this afternoon, but there's a lot of dates in the indictment. But he's also going to tell you that the state is not restricted to the dates in the indictment. The date actually doesn't matter. What matters is the number of times that the child was abused. And I will tell you right now that some of the dates may not line up exactly with what Dr. Darrisaw testified to. But legally speaking, that may be an issue on us when we drafted it. But it has absolutely nothing to do with whether or not we have proven all of those individual counts, and we're going to go through all that. The judge is also going to tell you that the statute of limitations means when the prosecution started. He's going to read you a thing about whether or not this case is within the statute of limitations. I can tell you it is, all right? This case was indicted in, you're going to see, 2017. That is within the statute of limitations for all of the charges that he's going to read to you. The number of counts, I said, there's some legal reasons as to why indictments are drafted the way they are. I'm not going to bore you, but I know Ms. Mull mentioned it at the beginning. There's 49 counts. There's legal reasons for that. Your job here today is to determine whether or not the state has proven each and every single count. You also have to consider the defendants separately. So you don't decide them together, you decide them as individuals, and you also decide each count individually for each defendant. Another way just to make our lives more complicated and your lives more complicated is in the law, and means or. What do I mean by that? If you see in the indictment that we have charged something that there were multiple injuries in a single count, if we prove just one of those injuries, we have proven that particular count. I'll give you an example. Count 2 is felony murder with the underlying facts of an aggravated assault being done to the abdomen, pancreas, liver, and mesentery. If we've proven even just one of those, we've proven that count. See, and, means, or. We have to make things more complicated. Probably why lawyers, they like to keep themselves in business, right? So let's talk now about the crimes charged. There's a lot of them, so it's going to take a little while to go through. I've kind of grouped these by the way it made most sense in the indictment to try to make it a bit easier for all of you. The murder counts. you're going to hear several different types of murder counts. Jennifer Rosenbaum is charged with murder, malice murder, and she's also charged with several different types of felony murder. So count 1 is malice murder. Count 2, felony murder with the underlying aggravated assault. Count 3 is felony murder, and there's an associated charge with that of cruelty to children in the first degree. I promise we're going to go through all these. Count 6 is felony murder, and the underlying count is aggravated battery. And just so you all know, you will have a copy of the indictment in the room with you. What is malice murder that Ms. Rosenbaum is charged with? It is unlawfully and with malice of forethought, either expressed or implied, cause the death of another human being. Okay, so what does that mean? Let's talk about implied malice. Malice may be implied when there's no considerable provocation. And let's think about that for just a second. What considerable provocation could a 2-year-old, how could they ever provoke an adult? How could they ever do something that would justify murdering them? Clearly, there's no considerable provocation to justify murder. This isn't a situation where someone pulls out a knife, pulls out a gun, says, I'm going to kill you. She's 2. And when all the circumstances of the killing show an abandoned and malignant heart, if you are causing blunt force trauma to a child's abdomen, that is the definition of an abandoned and malignant heart. So we've proven that she is unlawfully, and with that malice, with that implied malice, we have proven that she caused the death of Layla Daniel. Because again, there is no provocation that a 2-year-old could ever do to justify her murder. And when you stomp her, or punch her, or knee her, causing all that damage to her insides, how much more of an abandoned and malignant heart could a person have? Malice, to constitute murder, the homicide must have been committed with malice. Legal malice does not mean ill will or hatred. She didn't have to hate Layla. Is the unlawful intention to kill another person without justification, excuse, or mitigation. And what justification, excuse, or mitigation could there possibly be in this case? And here's the other thing, ladies and gentlemen. Malice can be formed in an instant. It's not something you have to wake up in the morning and say, I'm going to kill someone today. But when you decide you are going to punch someone or knee them, or cause that kind of internal injury to their body, you've committed legal malice, constituting murder. The judge is also going to tell you that Georgia law does not require the state to prove motive. I've been doing child abuse cases for many years now, and I still can't understand why someone would abuse a child. I still can't understand why someone would beat a child to the point where they die. It doesn't make logical sense. Dr. Messer talked to you about some of the reasons why people abuse kids. Maybe they're stressed. They have unrealistic expectations as to what parenting is really going to look like. You, I don't know, adopt a 2-year-old and a 4-year-old who have been bounced around from home to home in the past year, and maybe things aren't going exactly the way you want. Maybe being a 3rd-year law student at Emory is a bit more stressful. Maybe all these things going on in your life have caused you to be stressed out to the point where you were taking it out on the children. Maybe this is discipline gone horribly wrong. Whatever it is, the state still doesn't have to prove the motive, because I can't get into that line. Felony murder. Jennifer Rosenbaum is charged with felony murder, and what does felony murder mean? That during the commission of a felony, so the felony being aggravated assault, cruelty to children in the 1st degree, or aggravated battery, a person causes the death of another human being. And see, in this case, it doesn't even matter if we prove malice or not. If you are committing a felony, and someone dies as a result of it, you are guilty of felony murder. That says how straightforward this is. And under the law, aggravated assault, cruelty to children in the 1st degree, and aggravated battery are all felonies. What is aggravated assault? You assault another person with an object, which when used offensively against a person is likely to or actually does result in serious bodily injury. And we don't know exactly what she used. The law doesn't require us to say exactly what it was, but clearly based upon the circumstances of the injuries that you see to both girls, clearly whatever they were using was able to cause serious bodily injury. Hands, actually, under the law, can be those kind of deadly weapons. So when you see the knuckle marks on Layla's back, those hands were used in a way that committed an aggravated assault. Actual injury under the law does not need to be shown, but in this case, it has. Cruelty to children in the 1st degree. You maliciously cause a child under the age of 18 cruel and excessive physical and mental pain. Here's another example, though, where that you see in the indictment that says "and," so physical and mental pain, and means or. Malice is not ill will or hatred. Malice means an actual intent to cause the particular harm produced. So did you mean when you maybe hit Millie with an object that caused those bruises on her side that went across her buttocks, onto her back, crossing multiple planes in a patterned way? Did you mean to do that? Yes, you did. Without justification or excuse. And again, what justification could you possibly have to do that to a 2-year-old or a 4-year-old? Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such a particular action may occur. If you punch a child in the stomach, that's such a wanton act that you should know what's going to happen. You should know that something bad might come from that. Aggravated battery maliciously causes bodily harm to another by rendering a member of his or her body useless. Here's something then. Useless does not mean permanently useless. So if for a while, let's say for an hour or two, it hurts and you can't use your arm that was broken, or you're not walking correctly. Maybe you're having pain back here from your rib fracture. Those are, under the law, those are examples of being useless. Does it affect the way that the body part is normally used? Again, malice is not ill will or hatred. It simply means the intent to cause the particular harm produced without justification or excuse. What justification or excuse could there be in this case? We'll now go through the felony murder counts that she's specifically charged with. She is charged with committing felony murder by inflicting blunt force trauma to the abdomen, to the small intestine, to the liver, and to the pancreas. And when we talk about small intestine, Dr. Daris, I'll talk to you about how the mesentery is a much more specific definition of the part of the small intestine that was damaged. Count 2, felony murder with that underlying aggravated assault, punching someone. So if you believe that she punched her or kneed her or did something in some way to cause that internal bleeding and she died as a result of it, the state has met its burden of proof. Cruelty to children in the first degree. If she caused pain, mental and physical pain, to that child, and as a result of that, Layla died, the state has met its burden of proof. Aggravated battery. If she caused a portion of her pancreas, which was split in half, or her liver, which was gushing blood, her mesentery, which was gushing blood, if she caused those body parts to be useless, and she died as a result of it, which she did, the state has met its burden of proof. That's what we're talking about when we're talking about the charges in this indictment. And as far as how with Joseph Rosenbaum, by committing those acts, she committed felony murder. How about Joseph Rosenbaum? He's charged with murder in the second degree. It's a slightly different charge. He's also charged with cruelty to children in the second degree. So what is murder in the second degree? Murder in the second degree means during the commission of cruelty to children in the second degree, someone dies. And here's another thing. We don't have to prove malice. I don't have to prove malice regarding Joseph Rosenbaum. Simply by committing cruelty to children in the second degree, if Layla died as a result of it, the state has met its burden of proof. So what is cruelty to children in the second degree? When such a person with criminal negligence, when the foster father knows what's going on in that household, because what did Millie tell you? He would be there when Jennifer would hit them. One time he did hit them. But she also described he would be there when Jennifer hit them. One time he put icy hot. She just kind of described it as being cold and hot. And what did we see from the search warrant? Icy hot. He knew what was going on. It was negligent of him to leave those children in Jennifer's care. And as a result of that, Layla died. That is murder in the second degree. That is what we have proven during the course of this trial. He had an act or a failure to act. How much more of a failure to act could there be, knowing that your wife is abusing these kids and you leave them in their care regardless? Party to a crime. We're going to talk a lot of, when we start going through the individual counts, we're going to talk a lot about specific acts that Joseph is also charged with. So what does party to a crime mean? Party to a crime means a person is a party to a crime if that person directly commits the crime or intentionally helps in the commission of the crime, which could include covering up the evidence after the fact. So if you are putting clothes on the child to hide the injuries perhaps from those around you, if you are putting icy hot or you're tending to the injuries instead of getting care for that child, that's aiding and abetting in a criminal sense. That's party to a crime. That's why Joseph Rosenbaum is charged in these indictments. That's what the law says he did. Knowledge on the part of the defendant that the crime was being committed and that he knowingly and willingly helped or participated. Millie said he would do nothing, but he watched. Excuse me, Millie said he would watch and do nothing. He bathed and dressed them. We had multiple witnesses say that. Even their last witness today told you that. In the weeks leading up to Layla's death, he was part of that. He saw them naked. Would put on cream that, quote, smelled like old people and got hot and then cold. aiding and concealing older injuries by clothing them, and the day of, what do we know he did? He helped Layla go to the bathroom. Ladies and gentlemen, Dr. Darisaw told you that not every single one of those injuries that was on Layla's body was acute, meaning that some of the injuries were visible prior to him leaving. And in Jennifer's own statement, she said that Joseph ate and helped her use the restroom. That's what we're talking about. Let's start going through the other charges that are in this indictment. We talked about blunt force trauma to the head. Count 10 and count 11 are the blunt force trauma to the head. And the date that's in the indictment is going to be November 17th of 2015. That is why Jennifer Rosenbaum is charged, and she's the only one charged from these counts. What it says is that causing blunt force trauma to the head by assaulting them and cruelty to children in the first degree. And Dr. Darisaw told you that some of the injuries that happened that day were acute, meaning that they happened in a matter of hours. She can't give you an exact time. She can't tell you that it happened at 5:02, but she can tell you that some of those injuries on the head occurred that day before any of that microscopic evidence was available showing healing. Count 12 and 13 charge both Jennifer and Joseph Rosenbaum with aggravated assault and cruelty to children in the first degree for injuries that occurred prior to that day. The date that's in the indictment, again, the state's not tied to that date, but the date that's listed in the indictment, just so you can reference it, is November 15th of 2015, causing blunt force trauma to Layla's head. Dr. Darisaw testified that some of the injuries on Layla's head, remember she had them both outside and inside, some of those injuries were at least 2 days old. That's why they're charged this way as well. Count 14 and count 15, cruelty to children in the first degree, there's a date range for those charges, for those injuries that occurred even older than that. Dr. Darisaw testified that many of the injuries were in different stages of healing, including different ages of those internal injuries. And then you also heard from the family testifying about different times that they saw injuries to the face. We heard a lot of testimony about that. We even heard from neighbors who saw injury. Those are the days. The date range that's listed in the indictment for your reference is October 20th to November 10th. But we're talking about the older injuries. If you find evidence that there was older injuries, the state has met its burden of proof there as well. So let's look at some of the injuries that we observed during the course of this trial. Ladies and gentlemen, those are lacerations. Despite what Dr. Sperry wants to say, everything we are seeing on the screen are lacerations. Nothing. That back there, I think Dr. Darisaw in all her years would know the difference between a nick and that large line that he wants you to believe was coming from shaving. Let's talk about the ear. That is injury, abusive injury. It was either consistent with kind of a pulling like this, and we know from other injuries on the ears of both girls that apparently they were either pulled or kind of hit in their ears quite a bit because there's evidence of other injury. But that's an injury. That's not infantigo. Dr. Darisaw would know the difference between that and infantigo. Dr. Messner, who was the head of the Child Abuse Pediatrics Program at Children's Healthcare Atlanta, would be able to tell the difference between that and infantigo. Again, we see the bruises on the top of the head. We see the bruises all over the head. They want you to think that Layla hurt herself all of these times in all of these different ways by bumping her head on the bunk bed. The defendant says in her interview she did it once. Once. That came from her mouth. There's clearly more than one injury on that child's head. Clearly. And they're all over. What was she doing? Just banging her head against the wall? You see evidence of under the chin and on the neck area. And here we go. Remember when Tessa was talking about this photograph? And she said, I can see a mark right there. That concerned me. What did Dr. Darisaw say? You can see it on the autopsy. And here's the thing. You might have to look at the original photo, because there's an even older one right about here. It doesn't come through quite as well when it gets projected up there, but if you go back and you look at this photo, it is clear that there's an older injury there that's almost completely healed. That's why I brought it up to Dr. Darisaw and had her look at it more closely. We see again, injury to the back of the ear, injury to the underneath of the chin. And this is not kind of like right here where you expect a child maybe to fall and bump their chin, it's more under. That's what was concerning to Dr. Darisaw. It was more under. That's the evidence that we brought to you, as well as the inside. Inside of her head. And I know it's not pleasant to have to look at these photos, but Layla deserves that we do. Let's talk about the back. We spent a lot of time talking about the back. So what are the charges that are relating to the back? Aggravated assault. Dr. Darisaw testified that the bruising on the lower back was acute. She only did one punch biopsy of the back. So the entire back area, she only took one punch biopsy. But she told you that the bruising on the lower back was acute. And they asked her, could it be consistent with being punched? And she said, yeah, the child probably was being punched in her back. Count 18 and 19, that talks about some of the older bruising. She also talked about there was evidence of older bruising on the back. There was more advanced healing with early scab formation. These didn't occur at the same time. Because at the top of the back, she found early scab formation that was already starting. The date in the indictment for your reference is this November 15th of 2015. And that's what we've been looking at. That's the injury. That immediately when the EMTs saw her, they were concerned. Who wouldn't be? You can see that she probably was punched. Or something of that. But you also see how they're in different, this is all the same part of the body. And clearly, they're in different stages of healing. Talk about the buttocks. We'll talk about the butt in a second, but you can see the pattern that Dr. Messner talked about. And Dr. Darisaw told you that the bruising on the buttocks was deep into the muscle. Again, this is upper back and lower back. Evidence that you've seen during the course of this trial. Ladies and gentlemen, again, you're allowed to use your common sense. How come not a single medical professional who does this for a living, not a single medical professional has ever seen anything remotely like this? How come? Because she didn't get these injuries from the Heimlich maneuver. And she didn't get them from CPR. Blunt force trauma to her chest, abdomen, and hip. Counts 20 and 21 with aggravated assault and cruelty to children again. Dr. Darisaw examined some of these areas microscopically, and she said that the injury at the left shoulder was acute because there were no neutrophil infiltrates present. Evidence of an older bruise on the left chest per the punch biopsy. Because in that case, there were those neutrophil infiltrates, so it was at least a few hours old. The injuries didn't occur at the same time. They're hours apart. Hours. Not minutes. Not a matter of 5 to 10 minutes. They are hours apart. That's what the science showed. Dr. Sperry didn't dispute that. The science showed that they were hours apart. Ms. Rosenbaum's only saying that it happened in a matter of a few minutes. Dr. Darisaw examined many of the bruises and injuries, but she did not biopsy every single bruise on that body. Again, the law doesn't require a microscopic examination. She actually went above and beyond, and her Dr. Sperry probably did 5 to 7 times the amount of work that a normal medical examiner would do. Because again, the child deserves that. Count 22 and count 23, cruelty to children, the healing liver laceration. Dr. Darisaw told you it's at least 2 days old. She can't give you a further outdate, but what she can tell you is that by 30 days, the research shows that it would be healed. And that 30 days is actually in reference to an adult. So in a child, it might even be quicker than that. But it definitely happened while Layla was living with the Rosenbaums. Not like Dr. Sperry wants to say that it was so old. The research shows that the type of injury, laceration that she had, we went through and said, remember the OIS-1 and the OIS-2, and he didn't dispute any of that. The type of injury that she had, the research shows, would have been fully healed within about a month. But we know it was at least 2 days old. There's also the hypopigmented area that we've talked about. The date for the indictment is October 15th. So let's talk about the chest, abdomen, and hip. You can see the healing, you can see the bruising here. This is a review of everything you've seen before. And again, here's underneath the arm. It's amazing that there's not a single bruise, though, over this area of the chest that she says she was beating on so far to try to give her CPR. Let's see, the hypopigmented area you see up here. Ms. McKee saw it a month before. Is she part of the conspiracy now? The other thing I found interesting about Dr. Sperry's testimony is when he was confronted with lie after lie after lie after lie that Jennifer gave regarding the leg, he was still like, oh, no, I mean, I can still say that this was an accident. But Ms. Mo gets up here and says, well, did you know that they were that Ms. McKee was Facebook friends with one of the family members, which actually wasn't true. Were you aware of that? And he was like, oh, no, I wasn't. But now that I know that, that would definitely cause me, I can't believe a word she says. Now, isn't that special? First of all, Ms. McKee wasn't Facebook friends. Ms. McKee, after hearing about it on the news, went and found a family member on Facebook and reached out to try to figure out who she needed to contact at the police department so she could go in and tell what she knew. She saw that area that was red a month before. Why on earth would she want to get involved in this? There's no external signs of punch or kneeing or punching. Dr. Darisaw and Dr. Sperry told you that you wouldn't necessarily see that. Because when you punch someone like this, the blood vessels actually have somewhere to go. Because you need the blood vessels to break before there's going to be a bruise. But if you punch someone or stomp someone or kick someone, the blood vessels themselves on the exterior may not show anything. But boy, on the inside, it was a different story. More evidence of the injury that were all over Layla's body. And they tried to say that maybe these were from fingernails? Come on. Use your common sense, ladies and gentlemen. What did Dr. Messner tell us about what those injuries really look like? Blunt force trauma to the vaginal area. Dr. Darisaw testified that some of the bruising was acute. She also said that some of the bruising had lymphocytes present, so there was a bit of aging. What does that tell us? They didn't occur at the same time. Not a matter of minutes, like Ms. Rosenbaum wants us to think that all of these bruises happened. They didn't happen at the same time. This is what the medical science shows. So for these two counts, it's November 15th. Again, the state's not restricted to that particular date. You see the injury here. And here's one of the issues, right, with their story. Why, if it's the injury maybe is from being pushed against the sink, why is this bruise vertical? Was she holding it against the sink like this? Bruises happen, the bruise pattern that you see happens by the object that it's in contact with. Look at all of the evidence here. Nothing supports what she says. The buttocks. Dr. Darisaw testified that there was superficial, the skin, biopsies displayed mild subcutaneous hemorrhage. She said that was acute. That probably did happen within 5 hours. The date for the date just for reference was the 17th. On the 30th and counts 30 and 31, per Dr. Darisaw, there was deep muscular hemorrhage with neutrophils present. So in the muscle of her buttocks, she had been hit so hard that there was bruising in the muscle of her buttocks that was at least a few hours old. That's what the science says. What are we talking about? We're talking about all this occurred because of resuscitative evidence. That's what the science showed. You can see on here the bruising that she sustained. Blunt force trauma to Layla's arm. There were 7 bruises on the right arm and there were 5 on the left. You also had to look at some of the interior photos. The right upper arm had a muscular bruise, the lateral right forearm, the left upper arm, the left forearm. All of these are inside bruises that she saw. We have to look at some of them. This is the evidence of the injury. Again, if you find even one of those you believe was from abuse, the state has proven those particular counts that we were just talking about. Look at that. You can see on the inside of her body the bleeding and the bruising. Fracturing her left arm. Cruelty to children in the first degree and aggravated battery. So here's where we get into the rendering useless. Ladies and gentlemen, you break your arm, you've rendered it useless. It hurts. Despite what Dr. Sperry wants to say that, oh no, she was probably running around and maybe hurt for a couple days and then she was running around. First of all, that's not supported by the science. And it's going to hurt anyone around the child. Let's assume what he says is correct for a second. For those first few days, anyone around that child is going to know that her arm hurt. She was crying. Why did all those doctors not find it? Because it didn't happen yet. The ulna fracture, the Dr. Darisaw will tell you that it was at least 10 days old. The other doctors told you that, and they could tell that from looking at the x-rays. But it's not more than 3 to 4 weeks old per multiple doctors, not just Dr. Darisaw. But you heard from Dr. Duxbury, a pediatric orthopedic doctor. Pediatric. He sees these kids every day of his life in his practice. And Dr. Darisaw also told you that there was advanced healing and new bone was seen. That's what she saw in the microscopic examination. It's not a non-union fracture like they want to try to say. What did the EMTs tell us? Immediately, when they were in the back trying to do life-saving methods, they picked up her arm to stick her for some sort of medical treatment, and they noticed, what's wrong with her arm? What motive did they have to lie? Why did they want to come in here and perjure themselves? What motive? The doctors and the nurses at the ER, they could tell that there was a deformity. And everyone in here can see it. There's a deformity there. This wasn't something that she was running around with for months and months and months, but they want you to think that because it looks real, real bad if she has yet another fracture that's unexplained. This photo, what did Dr. Sperry also tell you? Dr. Darisaw was manipulating it. She was actually pulling it. That's why it's coming apart like that, to take a photograph of it. She wasn't running around like that. There was healing that was going on, and you can see it in the x-ray. And I know that all of us, when we look at this, may not understand exactly what we're looking at. But that's why we have to rely upon the people who do this daily. And Dr. Duxbury and Dr. Mani, the radiologist who came in here, who literally looks at x-rays probably 12 hours a day, told you that that is a healing fracture. Dr. Mani may have used the word non-union simply because it hadn't fully healed yet, but he said definitively it was not, quote, a non-union fracture. He was definitive about that. That is a healing fracture, and you can see the signs of the healing kind of on the outside that I'm pointing to. That's what they look at, and they're going to see that callus formation. The arm was healing. It was about 3 to 4 weeks old. It happened in their care. Blunt force trauma to her legs, the aggravated assault, and the cruelty to children in the first degree. Again, multiple signs of trauma, both internal and external. That's what we're talking about in these counts. Let's look at this. How about this? Use your common sense. Does this look like an injury from holding a child up? Does that look like an injury from holding a child against a sink? No. She was abused. That's how these injuries occur. You also see other injuries on her leg. This is the back view of that. Again, your common sense, ladies and gentlemen, but you don't even have to just do that. You can also rely upon the experts who studied this and came in here and talked to you and gave you the tools necessary to look at all these things and say this was abuse. Fracturing her left leg. Again, cruelty to children in the first degree and aggravated battery. This occurred between 1017 and 1019 are the dates in the indictment. This was that proximal tibial fracture we heard a lot about from gymnastics. This fracture right here. Now, some of the doctors were concerned about the mechanism. Dr. Duxbury was concerned. What did Dr. Duxbury do? He called back to Hudson Bridge and talked to Miss Lowe and said, weren't you concerned about this? He talked to Dr. Eanes and said, weren't you concerned about this? And Dr. Eanes was like, well, now that you mention it, yeah. But she's actually with you, so if you need us to do anything, we'll do it. But, since she's with you, you can take care of it. So what does he do? He says, I need you to go to Children's Healthcare of Atlanta at Eggleston, to the ER. I will call up there. And she said what? I will go. That's what he said. He memorialized that in a letter that he wrote that day. You're not coming in here 4 years later and saying something different. He wrote it that day. I'm concerned about the history, so I sent them to Children's Healthcare of Atlanta at Eggleston, which, by the way, is located 2 doors down from Emory Law School. So it's not even like when they said, well, did you give her a piece of paper? She knew where it was. The doctors were concerned about it and wanted there to be a further workup. But what did she do? Oh, I'm not going there. I'm not going there. I don't want those people at Eggleston questioning me. Remember what you told Ms. McKee? I hate doctors asking all those questions. He expressed concerns and she ignored them. That is the evidence of abuse. That's how you can look at this and say these were abusive injuries. She gave different stories to different people at different times depending on who you were. Notice she never told Peggy or Tessa or Miss White anything about falling at Peggy's house. Because it didn't happen. Peggy would be like, wait, they hadn't been here in weeks or months. Tessa would be like, I don't think they've been over there a long time. So she left that part out. Convenient. Interesting that this one healed so quickly, yet they want you to think that other parts of her body are just, the other parts of the body can't heal at all. The ulna, that can't heal. The liver, that can't heal at all. But this one heals nice and quick. That's what we're talking about right here. That was the fracture. And the fact that she treated it this way is the evidence of abuse, that we can prove that this was child abuse. Fracturing her rib. Posterior rib fracture, all the doctors, including Sperry, testified that these are highly concerning for child abuse in children because they come from a squeezing. And not just like, ooh, I'm so happy to see you kind of squeezing, a squeezing like this, fracturing the child's ribs. That's what happened. But even Dr. Sperry said what? Oh, that's probably only 3 to 4 weeks old. Well, at least with that one he agrees with everyone else. Because everyone else who looked at this also said that it was about 3 to 4 weeks old and in their care. There's the evidence of the fracture right there and the signs of healing. Now we'll talk about Miller. Cruelty to children in the first degree and aggravated battery. Her left arm. Dr. Duxbury testified it was just a few weeks old per the x-ray. They testified this would be very painful. It wouldn't be something that, she probably broke it and no one even noticed. They all testified it would be extremely painful. But what didn't happen? Going to the doctor. That certainly didn't happen. Maybe after she went to Dr. Duxbury and he was on to her, she was like, we're not going to go down that road again. Too many questions. Doctors and their questions. Failure to seek medical treatment is evidence of her guilt. And his too, since this is party to a crime. He aided. He didn't get her treatment. He kept the lie going. He kept the facade alive. You can see that it's a few weeks old because of the periosteal reaction right here on the side of the bone. That's how they can tell when they look at this photograph, this x-ray, as how old it is. They're not just making stuff up. It's not just a guess. This is what the science is showing. Blunt force trauma to Emily's head and neck. This is count 44 and 45. There's clear evidence of bruising. Clear evidence of bruising in a highly protected area. Dr. Messer told you that an accidental injury to the neck, the likelihood of that is less than 0.2%. That's pretty low. And then you also got it on your ear, and then you also have these pattern injuries on your side that go across multiple planes. The petechiae. The petechiae come from a high impact velocity, like being slapped. Something like that, maybe it's a hand, or some type of object. That's how you get the petechiae. Experts acknowledge, including their expert, that this is highly suspicious for abuse. So let's look at it. You can see right here the petechiae along her neck. There's a closer view of that. That is evidence that she was smacked or in some way had blunt force trauma inflicted upon her neck. You can see the petechiae right here on the earlobe. You have to ask yourself, how in the world are you getting a bruise on your earlobe unless someone is pulling you or squeezing you like this or smacking you? That's what was going on. You see it on the back of her head. And what did Dr. Mesner told you? That's probably more consistent with kind of being smacked and the ear gets pushed in like this. How could you ever do that to a child? Her butt and back and hip, counts 46 and 47. There was clear evidence of bruising, pattern bruising. This is not from a fall down a ladder. It is across multiple planes, and it has to be a bendable object. To reach those multiple planes, it has to be a bendable object that is actually going to bend across those planes, maybe like a belt. That's the type of injury, that's the type of mechanism to cause what we see on Millie's side and her back and her butt. Now they put up Jennifer's sister to say, oh, I saw her fall the day before. But what did she also say? When she was shown the picture, she said, oh no, the bruise didn't look like that. Ladies and gentlemen, you can see what Dr. Mesner was talking about, the areas of sparing. You can see there are kind of lines, and then there's areas that are not injured. Ask yourself, how could falling down a ladder cause that? Especially when the witness said it didn't. How could it cause that across multiple planes? She would have had to fall, I guess, roll down multiple steps. That's what we're talking about. It doesn't make sense. Cruelty to children in the second degree. Last two counts. I promise I'm almost done. Count with criminal negligence, cause the child cruel and excessive physical and or mental pain by failure to seek necessary and adequate medical attention for the injuries that the child suffered. So, if you were supposed to seek treatment for, I don't know, your foster child who maybe broke their bones, and you didn't do that, that's cruelty to children in the second degree. And both of them are charged, first for Layla in count 48, and then for Millie in count 49. For Layla, she had a right leg fracture, she had a left arm fracture that would be painful, as well as older injuries. In Millie, she had the left arm fracture that also would have been very painful. The Heimlich and the CPR defense. Why the Heimlich defense? Why'd she use it? No one's saying that Jen isn't smart. She's a third-year law student at Emory. She knows the mechanism. She knows how she caused that injury. And what do they also say? That kind of delay is also indicative of child abuse. She knows how she caused the injury. Oh, God, she doesn't look so good. What am I going to say? Oh, I'll just say she was eating, and ding, ding, ding. Now we're Heimlich. You know what's also interesting? She tells everyone from the get-go, I don't know what I'm doing. From the 911 call to the EMTs to the DFACS worker, she's telling everyone, I don't know what I'm doing. Could that be because she's laying down her defense? Sure, she took criminal law already. They also talk to you that the pancreas is an extremely protected area, would require a direct blow. And what did Dr. Sperry even conceded that this kind of like pushing against the side, the force would be kind of spread out across the entire abdomen. It would cause a direct blow. That's what happened that transected her pancreas. And it's extremely unlikely that the Heimlich would have done that. In the one case study that we talked about, the one time in history that has been reported that the Heimlich maneuver has caused a transection of the pancreas, the child lived. The child had no other signs of injury. The child had no other signs of injury to their abdomen. So what did Layla have? All over her abdomen. I just showed you these to show you simply, you can't even see the pancreas because it's so protected. You can see pretty much all the other organs, but that's how protected the pancreas is. None of the bruises are in the area where the heart is located. Isn't that interesting? She may not have had child CPR, but I guarantee you she knew where the heart was, right? Dr. Darisaw did tell you that there was a small injury that could be consistent with CPR, but what did she also say? The amount of bleeding was so small, it probably happened when the child was at or extremely near death because there's very little blood. There's no blood pumping out from that. That right there could have actually been a small injury from CPR, but look, that's the heart itself, and that's the amount of blood that came out. Dr. Sperry, I'll leave you just a couple more slides and then I'm going to sit down. He's willing to say whatever someone will say, pay him to say. That was clear yesterday. It just was. He's no longer hired by the state, and when the defense tried to ask him that, he said, well, a few of my DA friends may ask me questions. He never said they hire me. He said they may ask me questions. And also think about this. He said, well, I left the GBI, and he did. He left that same week. Don't you think the GBI might have had an interest in having him leave quietly? Maybe we don't want to have this get too public. Maybe we don't want to have the fact that you've been stealing from the taxpayers for years as you've gone and testified elsewhere, yet still charge your time to the GBI. Maybe we don't want that getting out. Maybe we don't want that to be bigger than it already is. Because, hey, it might affect some cases. His opinion ignores basic facts in science, and he has a history of doing that. Just think about some of the cases that we talked about where he even said it. Yeah, you remember testifying in that doctor's hearing up in Ohio where the doctor said, sure, it's fine for a legally blind man to fly. Oh, well, no, the accident was caused by a heart attack, and he based that upon where the bodies were in the airplane, even though he'd never had any training in that. That's what we're talking about here. That's what he's doing here too. He based his opinion upon the word of Jennifer, and despite all the inconsistencies regarding the leg, he's still willing to base his decision on her word alone. That, in and of itself, speaks volumes. Don't forget, ladies and gentlemen, because in order to go along with Dr. Sperry's theory, you would have to also believe everything that Jennifer said. Don't forget about all the times she's lied, not just about the leg, but what about when she lied to all of you? What about when she lied about daycare and got caught in the lie? What about when she lied about working at Banana Republic on a certain day in question and whoops, got caught in that lie too? But also that was interesting, he changed it from accident to undetermined. Again, none of these medical professionals, ladies and gentlemen, had ever seen anything like the injuries Layla had regarding resuscitation. No one. These are just all of the injuries all over their bodies. And you have to look at all of the injuries and look at them in a constellation. You can't look at all the injuries in a vacuum. All of these injuries, all over their body, and inside of their body. Inside of Layla's body. How unlikely, how unlucky, and I said this to Dr. Sperry yesterday, how unlucky were these girls? Only one reported transected pancreas from the hind leg. Wow, that in and of itself is already unlucky. She's a medical miracle. But she also had multiple organs injured too. She's also unlucky because she also has an extremely rare non-union fracture that occurs in less than 0.2% of children ages 0 to 6. And even less likely because she has none of the risk factors and it was in her ulna. Her older liver laceration was not healing as quickly as medical literature would show. That's what Dr. Sperry wanted you to believe. Right? Gosh, she's really unlucky in that way too. Her liver doesn't even heal right. The neck injuries. She's real unlucky. She must be real unlucky there too. And Millie too. Neck injuries less than 0.2% from accident. Ear injuries are extremely rare. Layla receives injuries that no one has ever seen just from resuscitative methods. And both girls have highly unlikely injuries indicative of child abuse. You have to think that these are the most unlucky girls in the world. And in one regard, you're right. They were unlucky that they were placed with the Rosenbaum. They were unlucky they ever came into contact with them. What happened to Layla in the final minutes of her life? There was a blunt impact force trauma to her abdomen. More than once, given the microscopic findings. Given the microscopic findings that Dr. Darrisaw testified to, there was more than one blunt impact force to her abdomen. She had massive bleeding internally. She had bruises all over her body that were inconsistent with the history. And that bleeding caused shock. That's what Jennifer was talking about. That's what she was describing. The shock of that child dying in front of her. The seizures, those death seizures that Dr. Darrisaw talked to you about, which Jennifer probably did observe. She died a painful and a slow death. And think about this. The last person she saw was the person who killed her. I'm going to sit down for right now. Ms. Moe will have an opportunity to speak to you, and then Ms. Young will give the final statements on behalf of the state. Thank you.
Thank you, Mr. Chase. Just hold.
Ladies and gentlemen, good afternoon. We've been sitting here for 3 weeks now. It's taken 3 weeks and 3 attorneys to put forward what they presented to you as the simplest case in the world. We have needed Dr. Darrisaw, a number of doctors, a number of nurses, a number of paramedics, all to testify that this is obviously child abuse. Let's look at what actually happened in this case. What is this case about? It's about a rush to judgment, anger, rage, not by Jennifer Rosenbaum, but by the authorities when this child turned up dead. DFACS had to account for this. DFACS was sued. Money was at stake. People were talking about owning DFACS. To let it go by without a show trial like this would have been negligent at best. They are telling you that the medical evidence in this case is simple and clear, and these are just unlucky girls. There is nothing simple and clear about this case. Nothing. You have a woman who does not know how to do CPR, be it adult or child. You have a woman who does not know how to do Heimlich, adult or child. And this woman is put in the position that, as Dr. Sperry says, he wouldn't envy anyone being put in the position. The child is going down, she's choking, you can't seem to fix it, you try everything possible. And yes, you're giving thrusts into the stomach. And yes, those thrusts are like punches into the stomach of a little girl, because these are adult punches, not 3 fingers pressing in on the stomach. So yes, it was a Heimlich maneuver gone bad. Now, we heard a lot about the fact that these injuries had to have come from abuse. When you consider, ladies and gentlemen, that we have had a parade of witnesses come in here day after day, after day after day, to tell us that now in hindsight, what they saw was abuse. That they saw all sorts of abuse, but they did nothing about it. Did not call authorities, did not call defects, did nothing about it. And now, with the privilege of hindsight and the privilege of necessity, they look back and say, that was abuse, that was abuse, that was abuse. Yet these folks want you to believe that Joseph Rosenbaum, he, with his educational level, his occupational level, he is supposed to know what the doctors didn't know. He is supposed to know what the nurses didn't know. He is supposed to know what the orthopedics didn't know. Joseph Rosenbaum is charged in this case for one reason and one reason only, and that is to try and get him to turn on his wife. To say he knew she was abusing the children, and let me get a better deal for this case, and let me go about my business. But Joseph Rosenbaum did not see abuse. He did not see his wife do anything. He was working 2 jobs. He came home, he babysitted the kids. If there were bruises, they were the type of bruises that we have heard about and that started this entire case. Miss Lambert saw this horrific show of force on this child and decided to have pictures taken. She saw this example of horrible abuse and decided to have pictures taken. Ladies and gentlemen of the jury, you will have these pictures out and ask you to look at them and look at them carefully and see where on earth are the injuries. And ladies and gentlemen, if Joseph Rosenbaum saw skinned knees, bruises on legs, you mean to tell me he's supposed to take this child to the hospital? He's supposed to not let his wife sit with this child? There is not a single date listed, not November 15th, not November 17th, not October 10th to October 20th, not a single date when they can prove that Joseph Rosenbaum was anywhere near the children. First of all. Second of all, they can't prove that he did anything, that he watched anything, that he saw anything. And why is that? Because their witnesses are not worthy of credibility. Ladies and gentlemen, you will hear a lot, I imagine, about what Millie said. And what the state didn't want you to know is that Millie can't tell the difference between a lie and the truth. She can't tell the difference. She tells what she hears. Now, ask yourselves, how honest is the state being when they don't bring the last therapist to the stand? We have to. We have no burden. We can sit there like potted plants and do nothing. The law requires the state to prove beyond reasonable doubt. They didn't bring you the therapist who said, yes, she couldn't tell fact, we couldn't tell fact from fiction. Yes, Miss Amanda Harrell was very concerned about that because her memories were not accurate, were not true. And we're going to put that person on the stand and say to you folks, this is who you should believe. Does it mean she's a bad little girl? No. She's still cute, she's still adorable, she's still nice. She just does not have personal knowledge of what she speaks. She is repeating what she hears great grandma say, she is repeating what mom says. And how do you know that? Because of the whole starvation argument. Now, you will see on the charges as you get the indictment, there is no charge for starving any of these children. There is no charge for not feeding them adequately. So why did we bring it up? We bring it up because it shows exactly what the state did in this case. Detective Thompson is the first person to float the idea this child is thin. The next place we see it is with Millie, whose mother calls Mrs. Brown to come and talk to Millie. And as they're standing there, Millie says, they don't feed us anything. Now, where do you think that came from? That came from Detective Thompson talking to Peggy Banks, talking to Tessa Clendenny. That's where it came from, and that's where it was repeated over and over. And as the hatred for the Rosenbaums grew over the 4 years, more and more such stories were being told, to the point where defects had to say, and imagine, defects having to say, therapist, please tell mom not to talk to Millie about the Rosenbaums. There's just too much talking about the Rosenbaums. And yet these folks want you to believe that Millie just came out, testified to you about her own personal knowledge. This case comes down to what happened on November 17th. And on November 17th, ladies and gentlemen, Dr. Sperry testified that it was a chaotic, frenzied scene as Jennifer was trying to save this child. In the course of doing that, she unfortunately caused damage to the internal organs by doing improper CPR, improper Heimlich, and pounding on the back, and thrusting against the stomach. And think a little bit about Layla. She is slight, she doesn't have fat on her like I certainly do, and I'm showing you thrusts here. When you do a thrust with your hands on little Layla, that's going deep, and that's pressing up against the backbone, and that's causing the splitting of the pancreas. Now, Mr. Chase wants to make a big deal about the fact that there's only one study. That doesn't mean that there haven't been split pancreases. It only means that there's one study. And you need to be very careful when you go back and deliberate and think about this case. What we say, what Mr. Chase and Ms. Young and I say, is not evidence. It's argument. It's not evidence. Because Mr. Chase says something doesn't make it so. Let's talk a little bit about some of the things that he said that doesn't make it so. We talked to you about OIS 1 and OIS 2. What did that mean, and what did that have to do with anything? He engaged in a conversation about that with Dr. Sperry. We were not privy to what they were talking about. It was not explained. Was it OIS 1, OIS 2? What does that do for you? Misstatements. Miss McKee was a friend of Kimberly Smith, Layla's great aunt. She was a friend before Layla's death, she was a friend after Layla's death, and she remains a friend. And what is true is she sought information. Yes, she did seek information. She went on the Justice for Layla website and sought out information, took that information and went to the police 30 days after the occurrence. All of a sudden, she has some tremendous evidence to present to you, and you're supposed to believe that evidence. There's no evidence before you that Jennifer talked to this woman, just her word. There's absolutely no evidence. There's just this woman's word who comes out of the shadows 30 days after the fact, volunteers information she got out of Justice for Layla, and that she got in order to help her friend prosecute Jennifer and Joseph. Ladies and gentlemen, someone has to pay, and that's what this is about.
someone has to pay. But in real life, sometimes there are accidents. Sometimes you can't place fault at the feet of a person or persons. And that's the case here. There was an accident. Dr. Messner. Dr. Messner works for a child advocacy organization. They are there mainly to represent children. They believe children don't lie. They believe children tell the truth about abuse. But what did you hear? You heard that Millie tells stories, that she fantasizes, that she repeats what she hears. Dr. Messner says there are belt marks. He's the only one who says there are belt marks. Dr. Darasoff says, no, there are no pattern marks. I didn't see any. Dr. Sperry says, no, I didn't see any. But Dr. Messner comes up here, the advocate for children, and he sees things that you and I don't see. Dr. Darasoff testified that reasonable minds can differ. That the conclusions she came to are not necessarily the conclusions that some other doctor would come to. And that is in fact the case. Dr. Sperry admires Dr. Darasoff, hired Dr. Darasoff, thinks she's a great pediatric pathologist, but she made a mistake. Her conclusions were not the right conclusions. Dr. Sperry has amply more experience than she does. And not only that, ladies and gentlemen, Dr. Sperry was not contradicted by a single soul. You did not hear anybody come from the state, take the stand after Ms. Wells finished testifying today and said, let me tell you how Dr. Sperry is wrong, how Dr. Sperry is talking nonsense. If there was such a person, they would have produced them. If there was a doctor that could have gotten up there and said, what Dr. Sperry said is not true. What Dr. Sperry thinks is complete malarkey. If there was such a person, you'd have heard from them. But there isn't. Not even Dr. Darasoff came here, got on the stand and said, no, this is why he's wrong. Not even Dr. Darasoff. Motive to lie. Ladies and gentlemen, it's the American system of justice to get up here and say that defendants have motives to lie. Where is the presumption of innocence? Where is the innocent until proven guilty beyond a reasonable doubt? Immediately, because you're accused, you have a motive to lie. Did Peggy Banks have a motive to lie? She lied. Did she lie about big things? She lied about big things. She lied about Jennifer when she said that Jennifer was lying and did not say, was not told by her that Miss Lambert, they didn't want children with Miss Lambert because she was black. That was disproven entirely, and again, nobody got up there on the stand and said otherwise. Miss Banks got up on the stand, raised her right hand, and lied to you. Now, if she will lie about whether or not she's a racist, if she will lie about whether or not she reported something to police, if she will lie about mashed potatoes, then how can you rely on her for any testimony, especially about when she got the children? Again, you heard Ms. Wells get up there and say the dates that Peggy Banks took the children in November and in October. Ms. Banks said she didn't take the children at all. If nobody got up here and said Summer Wells is wrong, nobody got up here and said, proved that Peggy Banks got those children, and how can you believe Peggy Banks if Peggy Banks can't tell the truth about herself, sore as it may be, that she did in fact tell Jennifer that she didn't want her daughter with black people? That's what she said. She said it again to Lakeitra Billingsley, and she said it again to the third DFACS worker. Malice murder. Malice murder, you have heard, is a combination of the intent and the act to kill. The intent to kill and the act to kill. Where is the intent to kill? Where is the intent to do anything other than try and save this child? Where is Jennifer's intent to kill? They haven't shown it to you. They won't be able to show it to you because there is no such intent. And the judge will tell you that in order to find a crime occurred, you must find both intent and the act. You can't just find the act without the intent. There has to be what we call in the law mens rea, the mind's thought. Where is the intent to kill for Joseph? Where is the intent to do anything for Joseph? Except go to work, come back, babysit the girls. Has anybody said one thing in this courtroom about either of these young people having anything about them that reflects anger, that reflects malice, that reflects rage? There's been absolutely no testimony to that. In fact, the contrary is what you've heard. You've heard nothing but that these children were loved and cared for, and that they were clinging on to Jennifer, and they held on, and you have pictures. Ladies and gentlemen, we've distilled 2,000 pictures into perhaps a couple hundred. And you will be able to see the dates on those pictures, and you will be able to see how almost every date is covered, and those children are not bruised, they're not battered, they're not cut, they have no lesions on them. Dr. Sperry, who was not contradicted by anyone, told you you can't tell if those injuries are 5 minutes or 5 hours old. What you do know is they're acute. And you do know that they all happened at once, unlike what Mr. Chase said. They all happened at once. This was Jennifer's birthday. Where is the rage to come from? This was the end of finals. She's going to the Board of Commissioners meeting. Nobody has shown or proven that any of that is untrue. Where is the proof of anger, of rage, of anything bearing any resemblance to that? There is none. What you have to believe, and like what Mr. Chase said, is that she did wake up that morning and decide, this is a fine day to beat up Layla. Layla, who bore absolutely no threat to her. Layla, who's a sweet, cute, beautiful little girl. She had no reason to do that. What she did have reason to do is to try to save that child. And she did try to resuscitate that child by pounding on its back. And remember the 911 tape, which you'll have out and you can listen. You will hear that the paramedic on the 911 call said, you do 30 presses, an inch and a half down, 2 breaths, then another 30, and then another 30. We went up to a total of 30 compressions on this little girl's chest. 30 compressions on this little girl's chest being done with the adult CPR, followed by a 200-pound man who was doing CPR with his entire hand as well. And you wonder where she got the injuries? Eric Moreno testified, and he was attacked over and over again, and he kept saying the one thing that he was taught by the military is you give breaths, and then if you know CPR, you give CPR. That's what the manual said. That was uncontradicted. That's what his bosses told him. That was uncontradicted. And that's what he and Jennifer learned in the National Guard. You don't do CPR if you don't know what you're doing. Why? Because things like this can happen. You don't know what you're doing, you're extra forceful, you're being told you're not doing it hard enough, you need to be more forceful, and you end up going through the child's pancreas. That's why there is such a thing as a child Heimlich maneuver. That's why there is such a thing as child CPR. You have heard about felony murder. Felony murder is the killing of someone during the commission of a felony. Ladies and gentlemen, you will see on the indictment that you take out that there are groupings of charges for the head, cruelty and aggravated assault for the chest and buttocks and groin area. There are groupings of that. These are all counts in the alternative. You do not have to find Jennifer guilty of anything just because there are 49 counts on there. That too is calculated. That is calculated to impress upon you that, you know what, even if we can't prove the case as prosecutors, we can charge 49 times and we'll fool the jury. They'll think if they can get 49 charges out of this, she must be guilty of something. When in fact, she's guilty of absolutely nothing except trying to save the life of this child. The state wants you to believe not only that Millie tells the truth, but that Millie is what the paramedics are not. They are not people who can foresee the future. The paramedics did not know when the child died. Whether the child died in the house, on the gurney, on the way back, in the hospital, nobody could tell you that, except for Millie. Millie, the state wants you to believe, has the knowledge. Even though she told people she was upstairs when it all went down, she came down and saw her mother counting and pressing on the chest. But yet, she knows when her sister died, it was in the house. And, oh yes, by the way, she also knows that the organs were transected. It's amazing. She has X-ray vision. When you imbue a child with that kind of ability and say to a jury, you need to believe this child because she knew there was a transection, because she knew the child was dead, that's ridiculous. It's totally ridiculous. What happened is she heard her mother and her great-grandmother say that the organs were transected and that she must have died before she got to the hospital. There was nothing they could do for her at the hospital. She heard that. And she repeated it, as she's wont to do. She's 4 years old. Let's talk a little bit about the interviewing of Millie, because some of the statements come from the interviews. We have the first interview where she allegedly tells the interviewer, Jennifer's good to me. We go to the second interview, which happens right after the alleged death of her sister. And she says, no, they did nothing. Samantha White had asked her before, did they hit you? Did they kick you? Did they do anything to you? Did they spank you? Did they knee you? She said no. She went to the interview. She was asked there, did anybody spank you or hit you or do anything to you? She said no. Do they hit you? Do they spank you? No. And then we have the interview, the forensic interview, that occurs in the dining room of Miss Lambert, the circus that occurs in that house. Children are running around, Miss Lambert's in the room, the police, contrary to what they testified to, did bring in another child for moral support. That other child is then coaching Millie to say, oh, don't forget about this, and tell them about that. The coaching is done right in front of you. Right in front of you. It's not just mama and great-grandma. You've got foster family, children, foster mothers talking in the interview. And what does Millie say in the interview? She tells us something that we should take to heart. Did you watch the news? Haven't you heard? It's not coming from her personal knowledge. It's coming from the newspapers. It's coming from what she heard. And the detectives are peppering her with questions. It's not asking her one question at a time, letting her answer. It's suggesting answers. Did you hear Layla cry? Was it a little or a short time? Now, what kind of a question is that? Was it a little or a short time? How is that not suggestive? Now, the state brought in a number of people to tell you basically Children don't lie, children can't be coached, children don't learn from what they hear, children cannot be coached. So certainly Millie was not coached. Well, Millie was very smart, and as Dr. Powell told you, if children couldn't be coached, we wouldn't have a kindergarten and a pre-kindergarten program, because that's what we do. We teach them things in the kindergarten program and in the pre-K kindergarten. Just like her grandmother, her great-grandmother, and her mother, and the Lamberts and the Browns taught her. She got it from them, either intentional teaching or she picked it up from their conversation. But it did not come from Millie. And to sit here and say, Millie said that she was spanked by Jennifer and Joseph watched it. Nowhere did she mention that before she gets up on the stand here. It isn't said anywhere else. Anywhere where she's not coached, there is absolutely no statement like that. This is the first time she says that. Ms. McCullough came here and testified and suggested to you that Millie does know, is talking from her personal belief. But what does she tell you? She tells you that Peggy Banks is there for almost every session. And we know Peggy Banks coaches. We know Peggy Banks talks inappropriately about adult themes to children. We know that because we've heard that through the testimony. And she sits there in almost every session. And we know that in between the time of the funeral and the time that she goes to Miss Lambert, she also sees her mother. Because how do we know that? Because Miss Brown testified to that. She went to their house on 2 occasions because the mother called and said, Millie wants to see you. And conveniently enough, Millie had things to say when she came. And listen to what Millie says and the vocabulary she uses. Ms. Resort she said, I don't know, there are bad people out there and there are good people out there and I don't know the difference. Does that sound like a 4-year-old? And I submit to you, ladies and gentlemen, it does not. These are things she has repeated, things she has heard. The state said that there were bruises that were visible to Joseph before he left the house on the 17th. Where are these bruises? We have seen the bruises that ended up, but we have seen absolutely no evidence that there were older bruises that were visible to the eye. Nobody has testified to that. Nobody has told you that they were visible to the eye. Merely that in a microscopic examination, they appeared to be older. That doesn't mean that they looked older. That doesn't mean that they looked like bruises. To suggest that Joseph should know what the experts don't know, what the family doesn't know, is a bit rich. Impetigo, ladies and gentlemen, look at the ear. You can see the crustiness for yourselves. You can see the hair embedded in the crust. You can see where the child picked at it. To say that's a burn, it's, as you will see it's got 3 separate little welts. They're a bacterial infection that she also has in her nose area. But they're going to blame Jennifer Rosenbaum for that, too. And say that somehow or another, she slapped the child on the ear, and slapping on the ear gets you a bruise on the lobe. Children scratch themselves. Children get hurt. These were rough and tumble kids. By anybody that you've heard's description, these were rough and tumble children. They got hurt. They hurt each other. They pulled hair. You want to know why there's no hair in a certain area? When you take long hair and you pull it up, there's going to be bald spots. And to the extent that those are not a lack of hair, who was pulling hair? The girls were pulling each other's hair. We're going to blame that on Jennifer Rosenbaum too? We're going to say that she's sitting there pulling their hair? Mr. Chase says to you, maybe this is what happened, maybe that is what happened, maybe she was stressed out, maybe she had a lot of work at Emory Law School, maybe she felt pressured, maybe the children were acting up. Maybe does not mean guilt beyond a reasonable doubt. Maybe is doubt. They don't know. It might be this, it might be that. To the extent that there's a might be something else, you have reasonable doubt. Dr. Sperry's testimony is the definition of reasonable doubt. Dr. Sperry's testimony, especially because it was not rebutted, nobody got up and said it wasn't true. His testimony is there was an alternative way this could have happened, and it could have gone down in the form of bad CPR, bad Heimlich maneuver, and unfortunately, the child suffered and the child died as a result of bad Heimlich, bad CPR, pounding on the back of the chest, 90 compressions, 200-pound man following that. But we want to blame the Rosenbaums, for which there's absolutely no evidence. You've heard nothing about them to suggest anything other than that they are the people that this facade is all about. It's not a facade, it's who they are. Just because they don't know people that are good and kind doesn't mean that Jennifer and Joseph Rosenbaum are guilty of a thing. Mr. Chase says, well, you know, he shouldn't have put clothes on the children. He should have seen the bruises, and he shouldn't have put clothes. He should have taken the kids to the hospital. What bruises? Where bruises? All the bruises were done on the same day. Doctor said some were a little bit older, but she couldn't tell 5 minutes from 5 hours. Bottom line is they all occurred on the same day, and they occurred after he left. He can't be held to blame for his wife's CPR and his wife's attempts to save this child through the Heimlich maneuver, through the CPR, through pounding on the back, trying to get that item out of the mouth. What else does Mr. Chase say? Mr. Chase told you and tried to bring out the fact in Dr. Sperry that Jennifer had the house for 6 days before she gave a statement. But what he did tell you is what you know because you heard it from the police officer when he got up on the stand and said, Jennifer said there was chicken in the drain, aren't you going to collect it? So there was a first time, she did say it immediately. She said it right then to the police officer that responded, are you going to collect it? And what did they do? No, they didn't collect it. They don't care. Could mean the difference between a guilty verdict and a not guilty verdict, but they don't care. Dr. Sperry told you they could freeze it, they could analyze it, determine if it came out, if there were gastric juices in it. Do they do that? No. Why? Because they don't care. Beware of misrepresentations. Sperry told you it's a horse, not a zebra. What Mr. Chase says is not evidence. Let's talk about Dr. Duxbury. Dr. Duxbury, the infallible doctor who doesn't do a thing to stop what he considers to be a violent woman who has abused a child. He doesn't call the police. He calls the former doctor to berate him about it. He doesn't call anybody to say, this Jennifer Rosenbaum left here and she didn't go to the Eggleston Hospital like I told her to. We need to ask her some questions. Let's do a welfare check. That's what he's obligated to do. That's what he takes an oath to do. That's what it means to be a mandated reporter. You don't just get to call people up and berate them, check with Eggleston, make sure she didn't go there, and then sit on your hind legs and write letters to cover your own rear end. And while we're at it, how reliable is Dr. Duxbury? They want you to believe the dates he gave. And what do they say? They say, oh, you know, that's what Jennifer said. Jennifer also said that she was a foster mother. And in there, He or his nurse wrote adopted. That's not correct. History of abuse. That's not correct. So why should we take his dates as gospel truth? Arrogance, that's why. Arrogance and infallibility. If it's a doctor, you can believe them. If it's a doctor, they can do no wrong. Throw her into the maws of the law because a doctor said so. But that doctor didn't have the wherewithal to pick up the phone, call the Henry County Police, and say, do a welfare check on this child that didn't get her leg fixed. And then what do we find out? We find out that this doctor doesn't cover Medicaid, didn't cover the cast, didn't cover the shoe. What else is left? So yes, she went to another facility that did cover the cast and the shoe. It's not like she didn't go get treatment, she did. There's absolutely no evidence that she didn't call Eggleston and that they didn't say there was no appointment for that day. She went as quickly as she could to where she could, to where they paid Medicaid. The state doesn't want you to know that, and neither did the doctor. Because what did he say? I don't know nothing about money. I just rake it in, but I don't know anything about money. I don't know anything about billing. But isn't it interesting, he knows about everybody else's billing practices because he tried to tell you about what other people do. His own, he doesn't know anything about. But other people, he knows their business. Ladies and gentlemen, you have out with you pictures of the bed. It's a cute bed. It's a nice arrangement, but it is what we in the law like to call an attractive nuisance, which means it's very attractive to kids to do on it what they shouldn't do on it. Just like swimming pools are very attractive nuisances, they attract kids to do what they shouldn't do, which is jump in the water. And these beds attract kids to jump on them and to try and touch the ceiling. Sometimes your hand touches it, sometimes your head touches it. And how many children have you seen fall down, hurt themselves, get right back up, go right back on the bed, and jump some more? $49 counts. Because you couldn't hold anybody accountable in less than 49 counts. Because you couldn't do a count of murder, a count of aggravated assault, and a count of cruelty and call it a day. No, because we are being driven by an agenda. And that agenda is to blame somebody for what happened, whether it be accident or not. We're not going to let DFACS take the hit for all of it. We're not going to let the state pay out money to this family and not have somebody to hold responsible. That's what this is about. That's why there are 49 counts. All these people that now come and tell you, oh, it was abuse. Amazing how they have 20/20 hindsight vision. But where were they? Way back when. Where were they? Peggy Banks and Kim Smith. It wasn't their fault. They didn't need to tell anybody. They just relied on Jennifer, because that's what you would do as a parent whose child was in foster care, is you would rely on the very person who you think is abusing the child. And you throw your hands up and say, I didn't know, I didn't know. We call DFACS? No. Did we call the police? No. Did we go and talk to the caseworker? No. Did we, as the mother of Jennifer, did we, as the mother of Layla and Millie, did we say take the children out of the Rosenbaum home? No, we didn't. Miss Tessa Clendenny tells you she did, but we heard from the DFACS workers, she never said take the children out of the Rosenbaum home. And ladies and gentlemen, we talk a lot about, and we have brought up a lot about lying and misstatements. And why is it important? If you lie about the small things, you're going to lie about the big things. And here, ladies and gentlemen, they're lying about Jennifer Rosenbaum. They certainly are lying about Joseph Rosenbaum, who wasn't anywhere in the vicinity. Yet you can go back and see where they have lied and lied to you. Miss Lambert. Miss Lambert comes up with this notion, and it's interesting given that we're being filmed through all of this. We're being videotaped, whatever the modern term is for that. It's interesting that Miss Lambert comes in and says, you know, Millie told me Joseph hit her on the back. Now, you heard Detective Thompson and Detective Mellon say, be sure and tell us if she says anything. She never told a soul. Because you know what? Because they didn't ask her. That's what she would have you believe. How about evading responsibility like that? They didn't ask her. She was very willing to talk about other things, but the secrets that Millie told her, she wasn't going to tell anybody. But what's interesting about the fact that we're being filmed and that Miss Lambert comes up with this idea that Joseph is the one that hit Millie on the back. She sat and watched the opening statements. She's not supposed to do that. She was told not to do that. We sequester witnesses. They're not supposed to view what happens on
Objection,
TV.
Your Honor, this person's arguing to evidence that's not, stuff is not in evidence. There was never any testimony that Ms. Lambert watched an opening statement or anything of that nature.
Objection sustained.
Let's talk a little bit about Miss Hall, the nurse. This is taken 4 days after Layla fell down the stairs. You heard Miss Hall testify. She was covered in a bruise. Not only was she covered in a bruise, she went to see her a day later, and she had another bruise on her face. Yet 4 days later, absolutely pristine. Absolutely pristine. Everybody wants to be a hero. This is a small town. Everybody wants to be the one to bring people down. Where is the evidence that 3 days before this girl was hurt for the second time? That evidence is the same place where this evidence is non-existent. These are pictures taken November 11th. If the state would have you believe that a week or two before that, she broke her arm. Take a look at that. Let's talk about Miss Lambert. Miss Lambert says that Jennifer took the children on June 28th. Look at what's been marked as State's Exhibit 118. And Miss Lambert is very proud, and so are the defects, and so are we all, for the fact that she documents so well. But if you were documenting for before June 28th, why would you put it after? Why would you squeeze it in before June 21st? Here you have the June 21st incident, and then you have June 28th, she writes on top of June 21st. I submit to you, ladies and gentlemen, what she did is she told the story about subsequent bruises. And so she documented it after the fact. And how do we know that those subsequent bruises didn't happen? The way we know that those subsequent bruises didn't happen is because there's no pictures of it. She had these two pictures taken. She had these two pictures taken, and then after that, there was subsequent bruising, she testified, on June 28th. Where is it? If you would go all the way to defects to have pictures taken, you would do it again if it continued. And she's so very punctilious, she's so very detail-oriented, she's not going to miss an opportunity to document any bruises that she saw. She would have taken pictures. She didn't, because they didn't happen. Banana Republic, June 28th. Their witness testified that she worked that day with Jennifer. That she checked her schedule and they were scheduled that day. Not whether or not she got paid for that day. They were scheduled that day and they worked that day. The truth, ladies and gentlemen, is in the details. And that's why I said to you in opening argument, question everything. Just like Dr. Sperry told you, you have to see the horses and not just the zebras. Question everything. Much ado is made of the fact that Jennifer has said slightly different things to different people. You've got to understand what's going on. You've got to understand that this is a young woman who has just lost a child. She is stirring in her brain to try and figure out when this happened. She knows of one instance. Millie tells her of another instance. Does she always repeat what Millie says? No. Sometimes she just repeats what she knows, which is that she fell in gymnastics. And it's interesting that the gym tells you, you know, it couldn't happen. She couldn't have run out onto the grounds of the gym and played on the slide or on the bars. She couldn't have done that. Yet and still, she was able to take the class without signing a waiver, which they said you had to do, you had to sign a waiver in order to take the class. But Jennifer, being Jennifer, took a mommy and me class without signing the waiver. And then she doesn't say it happened in class. She says she fell from a bar. She's trying to help the girl up to get her to grasp onto the bars, and instead the girl slides down and falls. And then is limping. So she does something about it. There's no failure to seek medical attention. She seeks medical attention. That pink cast is evidence that she sought medical attention. The state paraded 3 or 4 witnesses in here, especially Ms. Espinoza, to suggest to you that Jennifer and Joseph were not sad enough at the hospital. But then we brought the defects workers in. They said, yes, they were crying. Yes, they were distraught. They were both distraught. They were both crying. So what did Ms. Espinoza see? Ms. Espinoza was upset that a child had these injuries. So whatever she saw, it was not enough. But the evidence is that they were sad, they were upset. That Jennifer was crying, that Mrs. Samantha White could hear Jennifer on the phone from the street. She was crying so hard. And ladies and gentlemen, people don't have to prove their sadness for other people. Everybody grieves differently. And everybody admitted that everybody grieves differently. It's interesting that Espinoza and Emma Carr don't see what everybody else sees, which is a very distraught and very sad Jennifer and Joseph. Millie said, seeing someone cry makes me cry, and that's why I cry. Who was she with? Jennifer. Who was crying? Jennifer. And make no mistake, ladies and gentlemen, Jennifer will go to her grave distraught about this. You don't go through something like this. She will blame herself for it, whether she's legally responsible or not. Ladies and gentlemen, you're going to hear the judge tell you that must disprove accident. They must disprove that an accident occurred. Dr. Sperry testified that it was an accident or something undetermined. And no one came to rebut him. not Dr. Darisaw, not Dr. Gowett, not anybody. Not Dr. Messner, none of the nurses, none of the paramedics. Nobody came in here to say that Dr. Sperry was wrong. Jennifer talked to everybody and anyone that asked her to. She talked to DFACS. She talked to the police. Even with her attorney present, they still sat there and answered every question. They were being filmed. They knew that. She answered every question. She talked to Dr. Sperry. Anybody that asked her to talk, she is more than happy to talk. She was more than happy to talk to DFACS. She was more than happy to talk to the police. She was more than happy to talk to Dr. Sperry. Beam or bars? She supposedly said beam to one person or bars to another. Ladies and gentlemen, that is assuming that the folks that are reporting this are in fact accurate as well. Could somebody have heard beam instead of bar? Surely. Does it have to mean that she said beam or bar? No. It could mean that they misinterpreted beam for bar, bar for beam. Why did we bring Detective Nawara in here? She didn't testify too much, you might say. What she testified to is that Millie said exactly what I asked Kia about. I said to Kia, isn't it true that Millie said a bear had scratched her, that that's how she got hurt? Kia said no, she looked at me like I was crazy. But indeed, we find out she told Detective Nawara that Millie said a bear had scratched her. You've got all these different statements. They want to hold Jennifer accountable for beam and bar. They want to hold Jennifer accountable for talking about gymnastics injury when she didn't talk about it happening at Nana's house, when she didn't know if it happened at Nana's house. She just got that from Millie, who we know is not the best historian. They want you to hold her accountable, but they don't hold their own witnesses accountable to that. And Detective Thompson asked him directly, did you not ask Kia to come in for moral support? And I used the word moral support. What does he say? No, I didn't. What did you hear on the tape? Can you come in for moral support? These are shortcuts to conviction. They want you to convict regardless of the evidence, regardless of the fact that people have lied, that people have misstated. In a few minutes, I'm going to be handing over Jennifer and Joseph's lives to you. I've had them for 4 years. I'm just going to ask you to take as good care of them as I think I have, to care for them as I think I have. And don't sell them down the river to the first merchant that comes along. Brings you pretty pictures and says these are injuries, when they could very well be as a result of CPR or Heimlich. Again, nobody rebutted Dr. Sperry. Nobody rebutted Dr. Sperry. They're in your hands. Thank you.
All right, thank you, Ms. Mull. Can you take a short break? I think we need to take a short break. Let's take a 2-minute back.